Greetings, hello, and thank you for tuning into our Facebook Live program. My name is Olivia Matongo. I am the Vice President of Programs at the Alzheimer's Association Illinois chapter. On today's program, we're going to hear from two champions of the Alzheimer's Association who are experts in their fields. They will walk us through some of the common legal and financial challenges that families and individuals encounter when facing Alzheimer's disease. Our first speaker is Jeffrey Schmidt, a member of the Illinois Chapter Board of Directors. He's an attorney with over 25 years of experience in trust and estate matters, including elder care and special needs trusts. He currently serves as a Senior Vice President and Director of Fiduciary Solutions at Fifth Third Bank. Our second speaker is attorney Kerry Peck. Kerry R. Peck is a managing partner of the law firm Peck Ritchey, LLC, where he concentrates his practice in trust and estate litigation, estate planning, administration, guardianship and fiduciary litigation, and elder law. His clients have included families, hospitals, banks, the state of Illinois, County of Cook, and the city of Chicago. Mr. Peck is a past president of the 22,000 Lawyer Chicago Bar Association. Mr. Peck has been appointed by the Illinois Supreme Court as the chair of the recently created Illinois Supreme Court Commission on Elder Justice. He was retained by the City of Chicago Department of Aging to rewrite the State of Illinois Elder and Abuse and Neglect Act. Kerry co-wrote the books Alzheimer's and the Law and Don't Let Dementia Steal Everything, published by the American Bar Association. He is also a frequent speaker at continuing education seminars for attorneys and healthcare professionals all across the country. We're so thrilled to have the both of you here and to learn from you and to hear all the exciting things that you have to share with us today. And so I'm now going to turn it over to Jeffrey and Kerry.
Thank you very much, Olivia. I think we are, Kerry and I are both proud and happy to be here to help Alzheimer's Association any way we can. I'd like to start today by telling a little story of Paul and Cindy. Paul and Cindy have been married for 30 years. Cindy worked at home raising their daughter, Julie. Paul's a successful businessman, having built his business from the ground up. Paul is still active in the business and, along with his two partners, has enjoyed significant financial rewards. Paul's daughter works for the company as a key employee. Paul is 63 years old and in good health, except for a finding of early onset Alzheimer's disease. Kerry, what steps should Paul and Cindy take considering this finding?
Well, I also want to say thank you for having me today, and we're thrilled to be here. I think that it's very important for people to understand that when they're diagnosed with Alzheimer's disease, they're focused appropriately at the beginning of the process, and this is really a journey, is to focus on the medical side of the issues, with going from specialist to specialist and learning as much as they can about Alzheimer's disease. But our program today really will encourage our viewers to focus on the legal side of the issues. And that's critically important. I want to draw your attention to an article that I wrote for the Alzheimer's Association magazine some time ago entitled "Now What? A Diagnosis of Alzheimer's Disease and the Legal Issues That Require Prompt Attention." Because Jeff and I are going to talk about those issues today. And the first thing a family should do when a loved one is diagnosed with Alzheimer's disease is sit down and determine, do we have any estate planning documents? And if we do, they should be updated and promptly reviewed. And if they don't, we should promptly encourage our viewers to get an attorney and get an estate plan done. So what are we going to do in conjunction with that estate plan? Where do we start? Well, when an individual is diagnosed with Alzheimer's disease, clearly their medical decisions are paramount. And in Illinois, we have two types of power of attorney documents: a durable power of attorney for healthcare and a durable power of attorney for property. Both of those documents are critical to an estate plan. Both of those documents should be used by an individual diagnosed with Alzheimer's disease. And conceptually, the fundamental underlying principle of this document is that I name someone to make decisions for me when I'm not able to make decisions on my own. So hypothetically, I name Jeff to make decisions for me when I'm not able to make those decisions as a result of the progression of my Alzheimer's disease for either healthcare or property management. And property management and property is a generic term. It doesn't really relate exclusively to real estate. It means all of the patient's assets, the person that's been diagnosed with Alzheimer's disease. So we want to start with those basic foundations as the backbone of our estate plan. Critical, because we know Alzheimer's disease is a progressive disease, and we know that the patient is some point in the future is almost certainly going to be unable to make decisions for themselves.
Couldn't agree with you more, Kerry. You mentioned going to see an attorney. I also would suggest it's important to pick the right attorney that is well-versed, such as yourself, in these areas, and not just the guy who handled the real estate closing. Make sure they have a good understanding of estate planning concepts, elder law, and the like. I think one other point I'd like to make at this juncture, given that it's an early diagnosis, we've just been diagnosed, it might be wise for the family to investigate the availability of long-term care insurance, which is a policy of insurance that is designed to help with some of the financial burdens should Paul ever need to be some 24-hour care, or should he ever need long-term care facility type arrangement. Going on with our story, unfortunately, Cindy, the spouse, has predeceased Paul. It appears, though, that they followed Kerry's advice and structured their assets that are held in trust. Now, Kerry, who should be the trustee of that trust? Is the daughter the right person, or would you recommend someone else?
Well, I think that in a normal set of circumstances, when these trusts are set up, and what we refer to these trusts, we're talking about a revocable living trust. Why do we want to use a revocable living trust? Because it's the state-of-the-art mechanism to avoid a post-death probate proceeding. And a post-death probate proceeding is an estate, an entity, opened up in the probate court in which the individual dies a resident of, meaning in Cook County, it's at the Daly Center, in Lake County, it's in Waukegan, etc. And it's important that you understand in Illinois an underlying principle. If a person dies with assets in their name alone in excess of $100,000, the law requires that we open an Illinois post-death probate proceeding, all entirely avoidable with proper estate planning that would incorporate a revocable living trust. Now, the concept of a revocable living trust is a rather interesting one, but it's one that we're going to discuss very simplistically here today. And that is, if you can envision a box and taking your assets and putting them all into the box that we call a revocable living trust, retitling those assets from your individual name. So in theory, we take Olivia's assets out of her name and we put them into the Olivia revocable living trust. Why do we want to do that? Because under the use of a revocable living trust, we avoid that post-death probate proceeding, critical to good estate planning. If we can avoid probate, we want to. Why? Because it's a public proceeding. It potentially can be an expensive proceeding, and it potentially can be a lengthy proceeding. So state-of-the-art planning today is revocable living trust. Please don't be confused by thinking you need to be the Rockefellers to have a revocable living trust. It's not true. Now, Jeff asked who should be the trustee. When we create the trust, you retain yourself as trustee. After you become disabled or die in the normal course of a husband-wife relationship, Cindy would be the successor trustee. But in our story, Cindy has predeceased her husband. So Jeff asked who could be the successor trustee. And the answer is Jeff's institution, the financial institution he works for, could be the successor trustee, or an individual could be the successor trustee. It's up to the family after discussions with their counsel. So these are important decisions. Revocable living trust is used during lifetime and post-death. Again, should you become disabled, you name a successor trustee to manage your assets while you're alive. That individual likewise would manage your assets when you die. So we can use a corporate fiduciary, a bank, or we can use an individual.
Kerry, I couldn't agree more. And I think the point you make about using the trust is well taken. Not only will it avoid probate, there are certain characteristics of a trust that can provide some asset protection as well. As Paul progresses with his dementia, he may become susceptible to undue influence. And if his assets are with an independent trustee, they are much less vulnerable to some nefarious deed. Would you agree?
I absolutely agree, Jeff. We are seeing so much financial exploitation of cognitively impaired older adults. It's an epidemic. And certainly the use of a third-party trustee, a bank, a trust department of a bank, so to speak, would be a great idea, because then Paul could not sign away the house or sign away his bank accounts or his brokerage accounts. So the use of a third-party trustee would really help preventing Paul from being taken advantage of.
Yeah, I agree. And thinking about it, if Paul did not heed the advice of the attorney, or the family did not get this done, typically a husband and wife, they would hold things in joint tenancy, all of their assets, their home, the real estate, the bank accounts, etc. And upon Paul's death in Illinois, and every state, the surviving joint tenant would become the owner. So in our little scenario, upon Cindy's death, Paul now is the sole owner of all of their wealth, all of their assets. And in Paul's fragile condition, I mean, what could have happened without the proper planning is scary. And if I should continue on with this story, Paul has slipped a bit further, but he still enjoys a lot of activities. He attends church and participates in the community. Paul met a new friend, Chelsea, and Paul and Chelsea got along quite well. Chelsea soon suggests that Paul give her his power of attorney for property and his power of attorney for healthcare, naming Chelsea as the agent. Because she explains he's now alone, and convinced Paul that the daughter did not have his best interest in mind. Unfortunately, this actually happens. This is not a made-up story. Chelsea takes Paul to her attorney, and gets named as the agent. She cleans out the money from the bank account, buys a new car, and heads off into the sunset. What could we have done? I think we've explained that a bit, but what could we do now, Kerry, in light of this new wrinkle?
Well, Jeff, we're seeing this type of problem occur every single day. It's a significant problem that our viewers should be aware of. You should take steps to protect your older parents, your grandparents, folks that you love and want to protect from financial exploitation. when an individual is being financially exploited, very commonly we are forced to file what's called a guardianship case. And that's a lifetime probate, so that Paul is still alive, but the disease has progressed to the point that he clearly is susceptible to being taken advantage of by Chelsea. She has done so. She has basically taken his assets away from him, or a portion of his assets, we hope, leaving him some to pay for his health care that he's no doubt going to need. But when we file for guardianship, likewise, that case is heard in the probate court in the county in which Paul resides in. And the purpose of a guardianship account is to have Paul formally declared by a judge to be incapable of making decisions as a result of his cognitive impairment from the Alzheimer's disease. So we would have Paul evaluated by a doctor, perhaps a psychiatrist, a psychologist, or his attending doctor perhaps can render an opinion regarding his ability to make decisions. It must be a medical doctor in Illinois, and that doctor will write a report determining whether or not Paul, in his or her opinion, is totally or partially incapable of making medical decisions for himself or herself and or financial decisions. Obviously, our focus here at the moment is financial. We want to freeze what remains of Paul's assets to protect them from Chelsea and to protect them for Paul's future use. And we want to make sure that Paul's assets are available, as I mentioned, to him. The court will appoint a lawyer to go out and talk to Paul to review his medical records and take a look at the situation and report back to the court both on Paul's mental state and whether or not Paul agrees. For example, in this case, who are we going to ask that be guardian of Paul? In an emergency basis, we're filing for temporary guardianship, and we could in fact nominate a corporate financial institution like the one Jeff works for as temporary guardian, or we could name an individual that would act in Paul's best interest. So fundamentally, at the end of the day, we want to get our hands around by court order a determination that Paul's not capable of making decisions for himself and freeze his assets so they can be used, as I mentioned, for him in the future. If Chelsea's allowed to take all of his money, Paul's going to end up going, becoming a ward of the state, which is not clearly what he intended when he worked his entire life for he and Cindy to live happily.
You're right, Kerry. And the guardianship proceeding, well, appointment of a guardian is very protective. It can be a burdensome, very public proceeding that could have been avoided by some basic estate planning, creating a trust, put that trustee in place to take over when you're no longer able to handle your affairs. And the family would have been much better off. Chelsea's in the wind in this situation, unfortunately, and Julie will probably call the police. But it is an important conversation to have with your family attorney. Make sure they're qualified to act and do the things that need to be done, creating the trust that Kerry talked about, creating those other documents, those powers of attorney, and of course a will where you could nominate a guardian should one be needed, but hopefully it wouldn't be needed. Kerry, do you have any further final comments?
Well, I just want to echo your comments, Jeff, and that is that preventive planning is really the key to success in this area. When an individual is diagnosed with Alzheimer's disease, they need to obviously focus on the medical issues, but they need to promptly get to the legal issues, because we've had a short discussion here today about some of the benefits and pitfalls that occur with planning and with not planning. And so my final takeaway here is, sit down and do the planning to avoid what you know are going to be some future problems. Regrettably, in our hypothetical, Paul his disease is going to progress. With our viewers, your loved one and your family, the disease is going to come to progress. And unfortunately, that means a continuing decline in cognitive ability. Take the steps to protect the family, and please consider doing it right away.
Right. You don't have to be diagnosed to do this planning. It's good for everybody. Thank you, Kerry.
Thank you, Jeff.
Thank you both so much for that presentation. One thing made it clear to me is the importance of communication after an Alzheimer's diagnosis between all parties involved. It can bring out strong emotions, so it's really important to listen to each family member, continue to talk and cope with the changes and loss together. If you would like more tips on communication, please do consider attending our webinar on effective communication strategies next week. The registration link is in the comments. As a reminder, we have many online resources available to help you with legal and financial challenges. The link is in the comment, and our 24/7 helpline is always available to you at 1-800-272-3900. We're also going to include that information in the comments. Well, Jeffrey and Kerry, thank you so much for joining us today and sharing your expertise with our audience. We look forward to continuing the fight against Alzheimer's disease together. Take care, everyone. Bye-bye.
Bye-bye. Thank you, Olivia.